Well, hello everyone, and welcome to this employment law session, this live employment law session, I should say. I'm Lior Samfiru, the employment lawyer. You see my name right there, and I'm here with you today, as I always am, to answer your questions, to make sure you know about your legal rights, your employment law rights. This is a live session where you get to ask me a question and I get to answer. I get to tell you what you need to know about employment law, about workplace rights, about your boss, about your compensation, about what the law can do for you. It's okay to ask, hey, what can the law do for me? What does it do? It's okay to ask that. You're never going to get answers unless you ask that question. And what a great opportunity you have right now to ask questions. I'm one of the founding partners of Samfiru to Markin LLPs. They call me the employment lawyer. You can find our firm operate in Ontario, in BC, and in Alberta. And once a week, I like to join here and log on and make sure that I'm available to you for your questions. Maybe you have a question about losing your job and about your severance package. Maybe you have a question about whether or not your boss treated you properly. Maybe you've been you've been a victim of bullying, harassment, poison work environment. Your job has changed. I think you get the idea. There's so many things you can bring up on this session to get answers, to get solutions, and to hopefully have a better understanding of what the law does. We have some of the best employment laws across Canada, some of the best in the world, frankly. Too many people don't know what the law does and what the law actually can do. Well, on this session, you'll know, you'll get those answers. Now, before I start answering questions, as I always do, I want to give you some other contact information. If you want to connect with me and my team off social media to have a private discussion or a private email exchange, so easy to do. Just go to employmentlawyer.ca. You see that address on the screen right now. It's employmentlawyer.ca. You can get the phone number there. The email address is there. You can fill out a form if you prefer. You can also read out a lot more about employment law and your rights there. So many tools there for you to educate you and inform you. That's your one-stop shop of anything employment law, employmentlawyer.ca. But right now I'm live. Take advantage. I want questions. I want lots of questions. I want to help you with your workplace situation. So don't just watch. Watching is fantastic. I always say it. Listening, but also, of course, asking questions and getting answers from me even better. So if you've just joined us, welcome. I'm the employment lawyer, Lior Samfiru with Samfiru to Markin. Let's get to answering questions. Ask your question as you're listening to me. I see questions coming in, so I'm going to answer them right now. Carrie has our first question. I'm 56 as of last month. I have worked for the same company for 15 years. I was given notice of employment termination effective October the 1st. They say that under the Ontario Employment Standards Act, they're only obligated to pay me 1 week of severance pay, but will pay me an additional week if I sign a contract. Am I entitled to 1 week of severance? Well, no. Carrie, depending on the job that you're doing, you're probably owed anywhere from 12 to 16 months of severance. Not weeks, not days, months. So this company completely got it wrong. They're confused. They're nonsense. You're owed 12 to 16 months. Now, the amount of notice that they give, if they give you notice today until October, so they gave you, 5-6 weeks notice, that 6 weeks counts towards your severance. Your total severance then is 12 to 16 months less the 6 weeks notice that you got. But that still means that they owe you potentially another year's pay or more. So, Carrie, no, nonsense. Don't believe that. I want you to connect with me immediately. Connect me through employmentlawyer.ca. Let me do what I do, which is to help you get the severance you are owed. It's very simple to do. It's very straightforward, and we will get that severance. It's not because I say so. It's because the law provides this amount of severance. So if the law says you should be getting 16 months severance, it doesn't matter what your employer wants to do. You're going to get it. That's why we have laws. By the way, this is how easy it is to ask a question. There's so much misinformation out there. Employers often are misinformed about their own obligations. So Carrie knows she's owed north of a year's severance, not a week or 2 weeks. Same with you. If you have a question about your situation, just like Carrie just did, I want you to ask it right now. If you just join me, of course, I'm Lior Samfiru, the employment lawyer, live with you here answering questions. Carrie did it. I want you to do it as well. I'm going to continue answering questions right now. All right, Steve has our next question. I have given my notice to my employer because I was going back to school in the hopes they would give me something part-time. Instead, they said they would have nothing and made me give them written notice now. Things have changed in my life and I will not be attending school as hoped. Can I cancel my notice or do I have to go through with it? So, first of all, if you've resigned, okay, for whatever reason, you are able to take it back as long as you do it quickly. What I mean is before the company has relied on it, before they've made arrangements internally to bring someone else to your role or they hired, etc. If it's a short notice, so if it's a short period of time, you can take it back. What I mean by that, let's say you resign on the Monday, you change your mind. Yeah, you could probably have a couple of days to take it back, but that's it. If you take longer than that, the company doesn't have to accept it. If you try to take it back the next day and the company says, no, we're not going to let you, well, it becomes a termination. And then they owe you severance, even though you're the one that resigned initially. So you have a short window, but it's a very short window. A day, couple of days, really not much longer than that. All right. So you can take that back. Keep in mind, if you're working full-time and you ask your employer to make you a part-time employee, they don't have to do that. Your employer doesn't have to agree to a change. So they can say, we don't have a job for you. So if you're not going to work full-time, you simply can't work here. That's okay. But if you resign and something changes, you want to take it back, you can take it back, but a very short window. You're not sure what to do, how to do it, contact me. Very easy to do. Employmentlawyer.ca, the way to do that. Again, employmentlawyer.ca. Right now, I'm still live here. I'm Lior Samfiru, the employment lawyer with Samfiru to Mark and LLP. I see more questions just came in. I'm going to answer them right now, but I want more questions. I want to be busy. I want to be barely managing to answer all the questions that you have. So ask. Again, you have time, lots of time still. So ask your questions. I'm Lior Samfiru. Again, let's get those questions answered. Corey has our next question. How long would it typically take an employment lawyer to write up a severance and working notice offers for an employee of a company? So I'm not sure if you're asking this from the perspective of the employer or the employee. So if you're an employer and you're asking your employment lawyer to write a letter of termination for the employee that they're about to terminate, well, if you're terminating the employee tomorrow, we'll have it ready tomorrow. If you're terminating someone next month, we'll have it ready then. So it doesn't take time. It's whenever you need it. If you're asking from the perspective of the employee, so I think you're having the terms confused. A lawyer for the employee doesn't write a severance and working notice. We simply send a demand letter to negotiate proper severance. That doesn't take long. We move on this very, very quickly. So we understand when someone loses their job, they can't wait. They need to resolve that issue very quickly. They need to get their payment now, not 6 months from now. So we move very, very quickly as possible. So if you lost your job, Corey, you or someone you know, you contact me ASAP. You reach out through employmentlawyer.ca, again, employmentlawyer.ca, and we connect, we help you, we make sure that you get everything that you are owed, that you don't leave any money that's owed to you on the table. Okay, employmentlawyer.ca to connect with me and my team, Ontario, BC, Alberta. You got it, employmentlawyer.ca. All right, let's see, more questions to answer. Angie has our next question. How long does it typically take for the back and forth process of negotiating severance, and how long do they have to respond once the demand letter is sent? Can we never hold them accountable? Toxic environment. So, well, if the environment is toxic, if we're negotiating severance, that means you're no longer there. Otherwise, we're not negotiating severance. So the toxic environment doesn't really factor into it anymore. How long does it typically take? Usually it should take a few weeks of back and forth. Now, if the company doesn't respond, then we have to take legal action. You can't force them to respond to a letter. You can force the company to respond to legal action, to a claim. Most of the times you don't have to do that. The company, once they hear from us with the letter, they'll respond, we negotiate, and we resolve it. Usually that takes a few weeks from beginning to end. If we have to take legal action, it will take a bit longer, but still a fairly short process. But again, every case is different. There's cases that resolve in 24 hours. There's cases that could take a year plus. So without knowing about you, about your employer, about what you're owed, any other complicating factors, I really can't say, but usually we would expect a few weeks. Angie, if you lost your job, don't be afraid of the process. In most cases, it's a straightforward process. We know what we're doing. connect with us. We will deal with it. We will get the company to pay what they're legally obligated. And if they don't want to, we'll make them. It's our job. So Angie, connect with me through employmentlawyer.ca. Again, employmentlawyer.ca, and we'll do what we have to. If you've just joined us, I'm the employment lawyer, Lior Samfiru. I'm here with you. I'm here for you, and I want to answer your questions. Now, before I continue answering questions, I've had a lot of questions already today about severance, about getting paid what you're owed if you lost your job. And I think it's extremely important for everyone to know just how much severance they're owed. You have a right to that knowledge. You have a right to understand how much severance the law says you should have. So I created a tool that allows you to find out in seconds how much severance you're owed. To find it, you go to pocketemploymentlawyer.ca. You see that address on the screen right now. It's pocketemploymentlawyer.ca. And when you're there, you simply click on the severance calculator. Ta-da, you're done. You answer 3 questions, and it's going to tell you how many months of severance you are owed. It can even calculate that in dollars. It's completely free. It's completely anonymous. No names, no phone numbers. You don't have to put in who your employer is. You don't have to put in a credit card number. It's completely free. It's right there for you. And you need that. And the reason you need that is you may believe, oh, I'm owed a week pay per year of service or 2 weeks, or this company is a small company. They don't have to pay severance. Nonsense. All that's false. It's wrong. Go to the severance calculator at pocketemploymentlawyer.ca. Get what you're actually owed. Okay? And find out there what that right information is. You can compare that with what you've been offered and understand. Company offered you 6 weeks, maybe you're owed 12 months. Check it out, pocketemploymentlawyer.ca, free and anonymous. And if you want to, you can contact me directly from the severance calculator. All right, I'm going to continue answering questions, but you have time as well. You can be that second voice on this session today, asking your question and giving me the opportunity to help you. So ask your question. Don't be bashful. There's no bad questions. There's only answers and solutions. So let's continue answering questions right now. Let's see who is next question. I think Trevor. Trevor has a next question. Can you be asked to reapply for a new position within the same company? I'm 65 and I've been employed for 30 years, and now I'm in a senior role that is being eliminated. I was told that a new position is a junior tech job. So no, you can't be told, or you can't be forced to reapply. But what you have to understand is you may lose your job. Now, you'd be owed severance. Someone in your situation would easily be owed 2 years of severance. That's because a company can let you go pretty much for any reason as long as they pay you severance. So you not applying for a different job within the company means the company is going to potentially let you go with severance. So you have to decide what's best for you. What the company cannot do is say, aha, because you didn't apply for another job, you've quit. That's ridiculous. Absolutely not. You haven't quit. If they let you go, they owe you severance. So the choice here potentially is between leaving with severance, i.e. being let go with severance, or maybe applying and taking on another job. You can decide if you want to do which of the two. But if the company says you've quit, you call me immediately, because 2 years severance is what you're owed. Now, Trevor, we know he's been there over 30 years and 65, 2 years. Usually 2 years, by the way, is the maximum severance. In some cases, you could get a bit more, but for most people, 2 years is the maximum, and certainly Trevor would be owed the maximum after all these years of service. So thank you for that question, and let's continue that discussion. If you need me, you can reach me through employmentlawyer.ca. Again, employmentlawyer.ca. Terrence has our next question. I've been with the company for over 5 years and just got hired with a direct competitor. My question is, should I give 2 weeks notice? Also, do I mention it's a competitive company, or should I leave that part out? My concern is if they feel it's a competitive company, they can fire me the same day. Well, if they fire you the same day, they still would owe you severance. They would still owe you for the 2 weeks you gave them. Yes, you should give notice of termination. Now, you may owe more than 2 weeks. You want to look at your employment agreement and see if your employment agreement says how much notice you should give them. Maybe it says 2 weeks, 3 weeks, 4 weeks. You should give the amount of notice that your employment agreement says. If not, certainly don't give less than 2 weeks. And if the company lets you go before then you absolutely have to get still paid for that 2 weeks. Whether you tell them you're working for a competitor or not, it's up to you. You don't have to. But again, if the company says, well, you gave us notice of 2 weeks, but we're letting you go today, they'll have to pay you for the 2 weeks. So that's not the worst thing in the world, right? You can get paid and not have to work. Probably a good thing. If there's any problems in that situation, Terrence, I want you to call me, okay? My phone number, my email address, you can all find that at employmentlawyer.ca. All right. If you've just joined this session and you're wondering who I am and what I'm doing here, well, let me tell you. I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP, and I'm here live answering questions about your workplace rights. I want to help give you the information that you need so that you can understand what the law does for you if you're faced with a workplace problem. I've been doing that for the last 15 minutes or so. I want to continue doing that right now, but you can ask your question as well. You can listen to other people's questions if you want. That's very helpful. You'll learn a lot. But isn't it better if you can ask me your question so I can help you understand your specific situation? All right, let's see. I'm going to continue answering question. Nat has our next question. My dad has been working for a company for 7 years. He's currently on sickness benefits because he found out earlier this year he has cancer. He went on EI sickness so he can do his treatment, but the benefits would end soon. Can he get regular benefits after his sickness benefits runs out? His company offered him severance pay, but he doesn't want to take it. All he wants is to return to after treatments are done. So EI sickness benefits, of course, he can get that. In terms of other benefits, he can apply for either short-term or long-term disability benefits under a work plan if he has that as part of his benefits plan. If he has a short-term plan or long-term disability plan, he should apply and he can get paid potentially till the age of 65 if he needs it. If he doesn't have that, he may be able to apply for CPP disability benefits. Okay, he cannot get regular EI benefits in this situation. So he can get EI sickness benefits if those runs out, disability benefits through a work plan. If those don't exist because it's not part of his benefits plan, then CPP disability benefits. So those are the options that are available to him. Nat, company's not allowed to let him go. If they let him go, have him call me immediately. Okay, employmentlawyer.ca to connect with me and my team. So let's make sure he does that. And wishing your dad all the best for a speedy and full recovery. Guys, see how easy it is? By the way, can't get easier than that, right? You ask the question, you type it in, you hit enter. I see it, I read it, I answer it, and we move on. That's how easy it is. I'm going to continue answering questions right now with me, Lior Samfiru, the employment lawyer. See, Angie has a follow-up here. Angie says, the firing was retaliatory in nature, and I trust you guys to get what I'm entitled to. Just know that they're going to drag out the process. Okay, so if you're already working with us, you're in fantastic hands. We will help you. Let's see. Was given no notice. Okay, so you're already working with one of our lawyers. You're smart. You've done the right thing. We will get this resolved. Don't worry about the company responding, not responding. That's our job to make them respond. So that's the nice thing about working with an employment lawyer like myself and my team is we deal with it. You don't have to lose sleep. What do I do? How do I deal with it? That's our job. We do what we need to do. We take that pressure off you, so you don't have to focus on that. You can worry about your health, your family, finding another job. We deal with everything with your former employer. So thanks for that, Angie, and good luck with everything. You're in fantastic hands with anyone on my team. All right. By the way, guys, come on, more questions. I want more questions from you right now. So ask them. Don't be bashful. Bring the questions on. Let's see it. Next question. And Judith has our next question. My employer says I'm not entitled to vacation pay as I'm my supply staff. Is this right? No. So if you are an employee and you get paid, you are owed vacation pay. Vacation pay is a percentage of the income that you earn. So you cannot work without vacation pay. So depending how long you've been there, it may be 4% of your income. So not only do you get vacation pay, you also get vacation time. Keep in mind, vacation pay and vacation time are separate things, but you get both. So no, you cannot be an employee earning income without earning vacation pay as well, in addition to your income. So Judith, no, that's not legal nonsense at all. By the way, If you're dealing with a vacation pay issue, an overtime issue, a holiday pay issue, for that you always have the option of contacting the labor ministry in your province, the employment standards ministry, depending on where you are, or the Ministry of Labor. Different provinces have different names, because they're able to help you get vacation pay, overtime pay, holiday pay, minimum wage. Absolutely, you can and you should contact them. What the government cannot help you do is to get your full severance. The government cannot help you pursue or even understand what your full severance entitlements are. So if you lost your job and you want to get paid for what you're owed, you cannot go to the government for that. Not ever. In fact, it could be misleading and you can lose your entitlements by doing that. But you can and you should do that if you have a vacation pay issue, overtime, etc. For that, you can and you should. Doesn't cost anything either. So hopefully that makes sense. And thank you for that question. Let's see, more questions. Ashley, how's our next question? I have been working with a company for 14 years that decided to contract out our work and let go of its employees. They offered 2 weeks pay per year for severance. They only paid me for 7 years instead of 14, and as I switched roles halfway through from a temporary to permanent. My hours were never changed. The work I did never changed. So first of all, you are a 14-year employee, not a 7-year employee. It doesn't matter if your job changed. Your full years of service count towards your severance. But that's not even the big problem here. The big problem is you're owed much more than 2 weeks per year. So even if they did 2 weeks per year for 14 years, that's still a lot less than what you're owed. So 2 weeks per year for 14 years, that's 28 weeks. You're probably owed a year's pay, so almost double that, okay? So you're owed 12 months. They have offered you 28 weeks, which is 6.5 months. So you're owed double that. So no, that's a wrongful dismissal. And by the way, a wrongful dismissal simply is a situation when someone has been let go and has not been offered or has not been paid their full severance. I'll give you a statistic. About 90% of people, when they're let go, they're actually wrongfully dismissed because they're not offered proper severance. They're not offered full severance. So the reason doesn't really factor into a wrongful dismissal. The situation why you were let go doesn't really factor in. It's about severance. Even if you're let go for a false reason, but you were paid proper severance, it's not a wrongful dismissal. Okay, wrongful dismissal is all about the severance. And most people, if they're let go, have been wrongfully dismissed. So you too, if you lost your job, doesn't matter if you work for a big company, small company, if you've been there for 2 months or 20 years, there's about a 90% chance that you've been wrongfully dismissed. You got to call me. You have to call me if you lost your job. Again, doesn't matter how long you work there. Doesn't matter what kind of job. You got to call me. Too many times I get calls from people after they've already accepted whatever the company was offering, and I have to tell them, I'm sorry, I know you accepted 6 weeks, you were owed 12 months, but I can't help you because you accepted it. So don't let that happen to you. If you lost your job, you call me. First person you tell you lost your job is your significant other. The second person is me. You call me at the office, and my contact information, of course, you can find at employmentlawyer.ca. Again, employmentlawyer.ca. All right, so let's see. Next question from Perry. By the way, still have a few minutes. Why not ask your question? You still have the opportunity. Don't ask it when I'm done because you're not going to get an answer, right? Ask it right now. You still have time. But Perry has our next question. I recently discussed salary with a coworker, and after she learned that I have a higher pay, she has complained to my boss and everyone else. I was approached by my boss and told that I should never discuss my salary. Is this true? It's not a good idea to discuss salary. There's no law that says you can't, but generally speaking, you should keep these things confidential, and your employer may even have a policy about keeping that confidential. So it's just a good idea not to discuss salary with coworkers. All right, let's see. Next one from YouTube from James. I was fired because my plant manager was doing a walkthrough and said I was sleeping when he went past my station. Is this enough for cause? Well, here's the thing, a few things. Number one, was this an isolated incident? Have you always had a perfect record and this is the only time you did something wrong? If it is, it's probably not going to be cause. Now, if it's the fifth time that's happened and they've warned you and you've done it again, then it may well be cause. So that's a number one thing to consider. Another thing is, what kind of a job? Is it a very safety sensitive position? In other words, can someone get really hurt if you fall asleep on the job? Someone could die and get really hurt. If that's the case, then it's a problem. It could be cause. On the other hand, if it's not that, it's not really a safety sensitive, it's not a good thing, but no one's going to get hurt, then it's not going to be cause. So context is important here. I want you to remember, I want all our viewers here to remember that it's very difficult to establish cause. Cause means you're let go because something is so bad that you don't have to get any severance. It's very difficult to establish cause. It's not enough for the company to show that you've done something wrong or a few things wrong, okay? For it to be cause, the company has to show that it's so bad that it's not possible to employ you. Very difficult. In my experience, most of the time when a company says, we have cause, we don't have to pay you severance, they're wrong. They still owe you your full severance. So definitely, in that situation, you call me right away, and you can connect with me through employmentlawyer.ca. Again, employmentlawyer.ca. All right, let's get a couple more questions in. Beard Guy, love the name. I'm going to have a baby soon. I won't be taking paternity leave, but I was wondering, would I be able to request accommodation from my employer for additional work from home days to support my newborn? Well, the only way you can is if you can't otherwise, or there's no other support for your son other than you working from home. So if it's just one of those things where hey, it would be nice for me, help me out, employer, they don't have to do that. On the other hand, if your wife is not there and there's no care, or God forbid, there's a medical issue that you need to be there for your son or your child, then they have to accommodate you. So the accommodation is if it's a must, if you need to be there, not if it's a preference. They don't have to accommodate preferences. They have to accommodate things that are necessary, that are must. So that's how that works. Now, not to say that your employer is not going to be more than happy to accommodate you and work with you. They might be. But in terms of do they have to? Only if it's a must. So that's up to you how you approach them. In most cases, they probably won't have to do it again unless you can show that there's just no one else. Thank you for that question, Beard Guy, and let me know if any problems happen. Let's see, Tony. I was fired for wearing a Make Canada Great Again hat on a dress down Friday. They put down misconduct on my record of employment. So, Tony, they're allowed to let you go because of that, but they have to pay you your severance. So it's not, you haven't really done anything wrong. So they're still allowed to let you go. Remember what I said earlier, a company can let you go pretty much for any reason so long as they pay you severance. So they can do that, but they have to pay you severance. What they cannot do is say, we're so upset that you wore that hat that we're going to let you go and pay you no severance. That's a wrongful dismissal. You got to call me right away. And frankly, even if they're paying you severance, you got to call me, because chances are whatever they're paying you is a lot less than what they owe you. All right. So, Tony, bottom line is if you lost your job, you call me. By the way, that should be a rule of thumb for everyone. If you had a job and you lost it, you call me, you email me, you connect with me and my team. Frankly, it's that important that if you don't like me, that's fine. I will give you the name of someone else. Okay, but you have to call and get legal advice if you lost your job, always and forever. So, Tony, hopefully that makes sense. To connect with me, employmentlawyer.ca. You see that on the screen, employmentlawyer.ca. All right, guys, this is the time that we've had for today. Lots of questions. Love it. Thank you so much for asking. Thank you for giving me the opportunity to talk to you, to help you, to answer those questions. I'll be back next week, but don't wait until then. Myself, my team, we're not going anywhere. We're just getting back to work. So you can connect with me today, tomorrow, whenever you need us at employmentlawyer.ca. I'm Lior Samfiru with Samfiru to Market LLP. Thank you again for joining me, and we'll see you again soon.